All right. This I have three case numbers here involving the same defendant, all style, State of Ohio versus Lisa L. Redmond. And you are Lisa L. Redmond, appearing there from the jail?
Yes, that's fine.
All right. This is a Zoom hearing being conducted on all three cases. Ms. Redmond appearing from the jail. Her attorney is Catherine Hapner, appearing from her office. Appearing from the prosecutor's office representing the state is Assistant Prosecutor King. Now we have proposed pleas in all three cases, but we also had a pending competency hearing matter because we just recently gotten the report, or got Ms. Redmond back before the court, and Ms. Hapner wanted some additional time. Ms. Hapner, are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Redmond?
Yes, I am.
All right. Since you're not seated next to your attorney in the courtroom, if at any time you need to speak with her or ask her a question, tell me, and I'll put the two of you into a breakout room, and then be just the two of you, and deputy will remain out of the room while that is going on, okay?
Yes.
All right. So before we go further, then, the matter of competency, we had that, I don't know, 10 days ago or something like that, and Ms. Hapner had wanted some time to review it and potentially speak with the interviewer. Ms. Hapner, have you had discussions with your client and you're satisfied to move forward with the report that was submitted back on November 3rd in 25-107 and 25-125?
I spoke with her as recently as yesterday morning. I spoke with her over the weekend, and we were prepared to go forward and accept that report.
Okay. All right. And anything else from the state regarding that matter?
No, Your Honor.
All right. Well, then, based on the report that was submitted on November the 3rd from the Forensic Evaluation Center examiner, the court finds that the defendant is able to understand the purpose and nature of the proceedings and to consult with her attorney in her own defense, and therefore the court will find that she is competent to stand trial. All right. Now, the next then is that I have in these three files 25 CR 107, in which she's charged with aggravated possession of methamphetamine, 25 CR 143, same charge, and also 25 CR 125. Now, I have these written plea agreements in each of these cases, Ms. Redmond, that indicates that you're going to plead guilty to those charges. There's one count in each case. I'll hold up to the screen the first page of 25 CR 107. It has your case name and caption and the plea of guilty form. You recognize that?
Yes, I did.
All right. And on page 3, there is a signature that says, a sentence that reads, "I entered this plea voluntarily." Below that is a signature, appears to be Lisa Redmond. Is that your signature there?
Yes, it is, Your Honor.
All right. In case number 143, the same thing. First page, I'll hold up to Cameron to recognize that.
Yes.
And on page 3, the same sentence, "I entered this plea voluntarily," and appears to be signature Lisa Redmond. And is that your signature?
Yes, Your Honor.
All right. And in 125, I'll hold that up. And is that, you recognize that document?
Yes.
And then page 3, the same sentence, "I entered this plea voluntarily," and signature Lisa Redmond. And is that your signature?
Yes, it is, Your Honor.
And when did you sign these documents, Ms. Redmond?
Yesterday.
All right. And when you signed them, did you understand that they were agreements to plead guilty, meaning there won't be any trial in any of the cases? The next step would be a sentencing hearing.
Yes, Your Honor.
All right. And did you have enough time to fully consider the matter before making this decision?
Don't worry about my house. I went in and pleaded guilty, and she said it'd be 3 years probation, and I can get that expunged and out my record after probation. Because
Okay. Well, okay. My question is, you understood that they were plea agreements, correct?
Yes. Yes, Your Honor.
And do you feel that you had enough time to fully consider the matter before making the decision?
Yes.
Okay. I mean, I know Ms. Hattner said she spoke with you, I think, Sunday as well as yesterday. And so you've had ongoing discussions with her.
Yes, Your
All
Honor.
right. Now, all right. Do you feel that you were forced or pressured into signing these agreements?
No, Your Honor.
So you did this voluntarily?
Yes, I did.
Okay. And you're going forward today voluntarily?
Yes, Your Honor.
All right. So, in each agreement states you're going to enter a plea of guilty to the charge. Now, in all three cases, the charge is aggravated possession of methamphetamine. In all violation of Section 2925.11 of the Ohio Revised Code. In case number 107, that is a third-degree felony. It carries a possible sentence of 9 to 36 months, a fine of $10,000, and a mandatory fine of $5,000. And then in case number 143, that is also a third-degree felony. It's the same penalty. And then 125 is a fifth-degree felony, and that's the difference is because of the amount involved. And that has a potential penalty of 6 to 12 months, a fine of $2,500. Now, you understand what you're charged with in each of those cases and what the penalties are.
Yes, Your Honor.
And if you should be sentenced to imprisonment on these offenses, the maximum total would be 36 months in 107 and 143, so that'd be 72 months, and then 12 months on the 125 case is 84 months. That means there's a maximum potential sentence of 84 months. You understand that?
Yes, Your Honor.
All right. And other than these three cases, are you facing any felony charges in any other cases?
None,
All right. And are you currently on community control or probation or parole or post-release control for a felony in Ohio?
no.
All right. Now, under the law, if you are sentenced to prison at any time on these cases, upon your release, the law provides that as part of the sentence, once you complete the sentence imposed by the court, that the adult parole authority does have the option, if they decide to exercise it, to put you under post-release controlled supervision for up to 2 years. You'd be supervised by parole officer under the terms that they set. If during that period of time they felt or they had made the decision after going through the process that you had violated those conditions, they would have the right to return you to prison as a sanction to serve an additional period of up to 9 months for a single violation. But there's a cap or limit of half of whatever the prison term was for all violations. However, should you be convicted of a new felony while on post-release control and sentenced to prison, in that case, that judge then would also have the right to sentence you for committing that offense while on post-release control in these cases to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
All right, now, it's not required that you be sentenced to prison for these offenses. You can receive what's called community control, which is the current term for what everybody used to call probation. And that means that you will be supervised by a probation officer under terms set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not compliant, they would file a written notice of that with the court. There would be a copy given to you. You would have a hearing at which you would be entitled to have an attorney to represent you. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke your community control and sentence you to a minimum of 9 months and a maximum of 36 months in cases 107 and 143, and a term of 12 months on 25 CR 125, 6 to 12 months. And then the total fines could be $10,000 in the first two cases, the third-degree felonies, and $2,500 in the others. So that makes a total of $22,500. You understand that?
Yes, Your Honor.
All right. Also, Ms. Redmond, if you were convicted of a felony while on community control and sentenced to prison, then the sentence in that case, in these cases, we ought to be served consecutively to one another. You understand that?
Yes, Your Honor.
All right. Okay, so in case number 125-CR-107, the indictment reads in on or about March 14 of 2025 in this county, you knowingly obtained, possessed, or used a Schedule II controlled substance to wit methamphetamine in an amount that equals or exceeds bulk amount or less than 5 times bulk amount, in violation of 2925.11 of the Ohio Revised Code. Case number 25-CR-143 is the same charge, except it alleges that it happened on or about June 11, 2025. And then in case number 125, the language is the same, except there's no allegation of it being over bulk amount. It's just any amount. And so that's the reason it's a fifth-degree felony. Now, Mr. Redmond, do you understand what it is you're charged with in each of these three cases, what the state said you did, when, where, and how they allege that you did it?
Yes, Your Honor.
And you discussed each of these charges, the evidence in the case, possible legal issues in the case, possible defenses that may be raised at trial, and possible outcomes of a trial with your attorney?
Go ahead.
I'm sorry, did you say yes? Oh, wait a minute. You haven't talked with her about the case?
Didn't read all what you read me.
I mean, you know what, she talked with you about what you're charged with, right?
Yeah.
All right. And then you talked about, what the evidence is and, that type of thing, of whether you would want to go to trial or whether you would want to enter into this agreement. You talked with her about all that. Okay.
I did.
All right. Are you satisfied with her advice and competence in this matter?
Yes, I am.
Has anyone threatened you to make you plead guilty?
No.
All right. Now, on page 2 of each case, there are a couple of sentences that are printed in bold and underlined, and they read as follows. In each case, defendant will enter plead guilty to the indictment, state defense, joint and recommend community control of substance abuse treatment. So is that your understanding of the agreement?
He said community control
And treatment.
I need
Yeah. Well, you'll be evaluated for treatment, but with 3 separate charges, if you plead guilty to 3 separate cases, most likely, there's going to be some treatment recommended. But again, you also have your physical problem that you're being treated for now. So obviously, that'll all have to be coordinated, but we won't know until we get the reports. So.
Right, explain this, Redmond, is that concentrating on her dialysis is probably her most important thing right now.
Right.
Should have an assessment for the SGD, and depending on what that says, but getting her physical stuff is probably her top priority at the moment.
Sure. So that's where we're at on that. You understand that then?
Yes, sir.
Okay. Now, under the law, Ms. Redmond, the court's not required to follow the plea agreement between the parties. I could follow it, most likely I will, but, it depends on what all the information is submitted at the time, between now and then. And so, the court could decide, based upon all the information that's presented, that would not be the appropriate sentence and there should be some incarceration imposed or a fine. Along the lines of what I've explained is available to you, which in this case would be a minimum of 9 months up to a maximum of maybe 4 months. You understand that?
Yes, sir.
Okay. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No.
All right, so you have constitutional rights you must understand before I can accept your pleas in these cases. First, you had the right to counsel, and I appointed Ms. Hammond to represent you since you did not have the money to hire your own attorney. Now, her appointment wasn't simply to try to work the case out, but to provide whatever defense may be available to you under the law that you would like her to provide. So, if you decide you don't want to do this, that you want to defend against the case, she'll continue to represent you and defend you in each of these 3 cases. And if you want to have a trial in any or all of them, then she would represent you in those as well. You understand that?
Yes, sir.
Right now, under the Constitution and the laws of the state, you have a right to have a jury trial in each of these 3 cases, which means that there would be a jury of 12 people selected from a group of citizens that live in Highland County that were summoned for jury duty on the trial date for that case. Once the jurors are selected, the evidence is presented, then the judge instructs that jury on the law. And then in each of these cases, the jury of 12 people would decide whether or not the state proved your guilt in each case, It would have to be by proof beyond a reasonable doubt, and that verdict would have to be unanimous in each case, meaning that all 12 jurors would have to agree on the verdict. Do you understand that?
Yeah.
Now, under the constitutional laws of this state, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. So what that means is witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination, purpose of which is to try to bring out evidence that may help your side of the case. You understand that?
Yes,
Now, under the Constitution and laws of the state, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to testify or provide evidence against yourself in any of these cases at any time. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. And if you decide you're not going to testify in any one or more of the three cases, the fact that you did not testify cannot be used against you in that case in any way. And in fact, no one's even allowed to comment about it except in one situation. If you were to testify or not testify in each of these, any of the cases, then the judge would instruct the jury in that case that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the constitutional laws of the state, you are presumed innocent of these charges in each case, until proven guilty by the state of Ohio by proof beyond a reasonable doubt on every essential element of the offense in each case. So what that means is that the burden of proof isn't upon you to try to prove you're not guilty in these cases simply because you've been accused. In fact, under the law, you're not required to present any defense at all in any of these cases. You may, but you're not required to. But whether you do or not in each case, the burden of proof will remain on the state of Ohio. Prove your guilt by proof beyond a reasonable doubt on every essential element of the offense in that case. And proof beyond a reasonable doubt is the standard, and that is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally, you entered a plea of not guilty. Ms. Redmond, the plea of not guilty denied the allegation in each case, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty in these three cases, that plea is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime, and that plea waives and gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. Though with that exception, your plea of guilty waives gives up your right to a jury or court trial. The waives gives up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. The waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives gives up your privilege against self-incrimination because in each case, if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence because in each case, because if you say you're guilty, then the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had in any of these cases up until this point. Now, if I should sentence you the maximum sentence in any of the cases, or under other limited circumstances, you could file an appeal in any of these cases. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, I am.
Now, do you have any questions about the charges or the penalties in any of these three cases?
Not at this time, no.
You understand it?
Yes.
You understand the plea agreement in each case?
Yes.
And again, you understand the recommendation on sentencing is not binding on the judge?
Yes, Your Honor.
You understand the terms of the plea agreement in each of these cases?
Yes, Your Honor.
Right? And you understand the plea of guilty and what it means if you enter a plea of guilty to each of these three cases?
Yes, Your Honor.
All right. Is there anything you would like to speak to your attorney about before we go any further?
Not this month.
All right, then is it your decision to go forward and enter a plea of guilty to each of these 3 cases pursuant to the terms of the agreements that we've just gone over?
Yes, Your Honor.
Then there's a charge in 25 CR 107 that alleges that on or about March 14, 2025 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance to wit methamphetamine, an amount that equals or exceeds bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code, a third-degree felony, carrying possible prison term between 9 and 36 months, fine of $10,000, mandatory fine of $5,000. How do you plead?
Guilty.
All right, as to the charge in case number 25 CR 143, which reads the same as the 107, except the date is June 11, 2025. Otherwise, it's the same language, the same offense with the same penalties. How do you plead?
Guilty.
All right, and then as to the charge in 125, which reads that on or about April 20, 2025 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance with methamphetamine in violation of 2925.11 of the Ohio Revised Code, the 5th-degree felony with a possible prison term of 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
All right. The court finds that on this date, in open court, defendant was advised of all of the constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. The plea of guilty is in all 3 cases accepted, and pleas of guilty are entered as to the charge in each of the respective 3 cases to which she's entered the guilty plea. The court is going to refer this matter for a pre-sentence report. It will also include an assessment for substance use disorder and or mental health issues. We'll set the sentencing date for April 16 at 1 p.m. Are you available then, Ms. Hapner?
Yes, I'm just checking. I think so. I think we scheduled one yesterday. Yes.
Okay. All right. Now, we'll have, for the moment, I'm going to continue the bond. I know there's a recommendation for probation and treatment. I'd like to have some information from the probation department before I would consider the modification of bond. One of the problems we have, Ms. Redmond, is that I know you have been undergoing dialysis and have other issues, but you hadn't been in touch with people, probation or your attorney or the court. So one of the things you'll need to do is think about how you're going to handle that and talk with probation. They'll be out to see you. And then Ms. Hapner can talk to you too. And then Ms. Hapner, once you feel you have some information, that she'll make sure that she does report and comply. I would, of course, entertain a motion then at that time to modify the bond.
I was on probation.
Pardon me?
I was on probation before.
Well, yeah, I know. But right now the issue is, you weren't reporting, and that's why we, now again, I understand you had some medical issues, but I'm not convinced that was the sole reason. So we'll just wait and see what the plan is, and as soon as they can get a plan in place to make sure that you're going to be transported to your dialysis as well as getting transportation to and from your probation appointments and where you're going to be living, then I'll most likely consider, a motion to release you on bond pending the sentencing. But again, your history's been a little bit spotty here in the last few months, and that's why we're at the point we are, and you're in custody. So anyway, what I'm saying to you is, I think we can get there, but I want to have more information, and Ms. Hackner needs more information presented to me and the state so we can make that decision. All right. Anything further from counsel? All right. Are you still in there, Lieutenant Brown?
Yes, ma'am.
Okay. I think we're using a different invite for the 10 o'clock cases. All right, this is case number 25 CR 172, State of Ohio versus Alan Ray West. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Danielle Whip, and you are Alan Ray West.
Yes, sir.
Mr. King, I have this plea form here, but it's not signed by the state.
I approach.
Yes. Thank you. I'm going to tell them, they're logging, I'm going to tell them we're going to do this case first. As soon as JD gets it. All right. Ms. Penwell, I'm doing another case here, so it'll be a few minutes. Just put your mic on mute, if you would, please. All right. This is a plea hearing. Mr. West is charged currently with aggravated trafficking, aggravated possession of methamphetamine, both first-degree felonies, tampering with evidence, a third-degree felony, and a forfeiture specification. And I have been presented with a plea of guilty form here, Mr. West, which indicates that you're going to withdraw your not guilty plea and plead guilty. This form is actually, including the entry, 5 pages. And it indicates on page 1 you're going to plead guilty to counts 2 and 4, count 2 being the aggravated trafficking charge and the 4 being the forfeiture. And on page 4, there is a sentence at the bottom of the page that reads, "I enter this plea voluntarily," and the signature appears to be Alan West. And is that your signature I'm looking at on this
Yes,
form?
sir. Yeah.
And when did you sign this form, Mr. West?
This morning, just a little bit ago.
All right, and when you signed it, did you understand that it was an agreement to plead guilty, meaning there's not going to be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And before you signed it, did you go over it with your attorney and have her explain everything to you?
Yes, sir.
And is this something that you and she had been talking about before today?
Yeah, we talked.
So, I'm sorry.
Yeah, we talked about it.
All right. So when you came here today, this is what you expected?
Yes, sir.
You're not surprised by anything?
No,
And you don't feel you've been rushed or pressured in any way?
no.
Okay. And you signed this agreement voluntarily?
Yes, sir.
Okay. Now, the agreement then, as I indicated, says that you're going to plead guilty to aggravated trafficking of methamphetamine under count 2 under 2925.03A2 of the Ohio Revised Code, a first-degree felony, and also count 4, the forfeiture specification under 2941.1417. So on count 1, the form indicates you understand there's a sentence that's mandatory under the law of at least 3 years up to 11 years as a minimum set by the judge, with the possibility that that could be extended by the by the Department of Rehabilitation and Corrections based on certain things that occur while you're incarcerated. And if those things occur, it could result in as much as 1/2 of the sentence imposed by the judge being added to the sentence by the Department of Corrections. So that means that the maximum sentence could be 16.5 years. The minimum could be 3 years plus 1.5. So that means that the maximum minimum is 4.5 years. The maximum, if you will, is 16.5 years. Plus, there's a fine available of up to $20,000, a mandatory fine of $10,000. You understand that?
Yes, sir.
Again, you understand there's no possibility of community control or probation. This is a mandatory prison sentence for this offense.
Yes, sir.
Okay. Now, are you currently facing any felony charges in any other cases?
No,
Are you currently on probation, community control, parole, or post-release control?
no.
Right. So, As I indicated earlier, the sentence that's possible, or is required here, is a minimum of between 3 and 11 years set by the judge. So under the Reagan-Tokes law, the way that that sentence might be extended by the Department of Corrections is that they have to, well, first of all, once you serve whatever term the court sets, as a minimum, once you get to that point, less any credit that you've had while you were waiting trial or transport to the prison, it is presumed you'll be released. And the only way that doesn't occur is if the Department of Rehabilitation has a hearing at which it overcomes the presumption that you should be released. And the information that's considered, the criteria considered in making that decision are what your conduct was while you were confined, your rehabilitation that you have undergone while in the prison, what threat you may or may not represent to society, whether or not you were required to be put into restrictive housing while you were in prison, and what your security classification was. And if the criteria, the findings regarding those criteria warrant it, then the department can extend the period of your incarceration beyond that set by the judge for a definite period. And they can do that on more than one occasion. However, they cannot extend it by more total of one half of your sentence. So as I explained earlier, for 3 years, that means they could extend it for a year and a half, making it 4.5 years. If you receive the maximum 11-year sentence, they could extend it for 5.5, meaning it would be 16.5 years. You understand that?
Yes, sir.
All right. Now, the charge in count 2 alleges that on or about December 2, 2025 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance in an amount that equals or exceeds 50 times the bulk amount, but is less than 100 times the bulk amount, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another, in violation of Section 2925.03A2 of the Ohio Revised Code. So that's the charge. Now, it's called aggravated trafficking in methamphetamine, and sometimes people say, well, I didn't sell anything. How is it trafficking? Well, it's what we used to call, back in the day when I was prosecutor years and years ago, possession for sale or possession with intent to sell. So that's now they call it a variety of aggravated trafficking, but that's the charge. Now, with the penalties I described. Count 4 alleges that on or about December 2, 2025 in Highland County, Ohio, that you had in your possession a known to 2018 Chevrolet Silverado with a VIN number in the indictment, that you transported methamphetamine in the truck, and that it's therefore subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined under Ohio Revised Code Section 2941.1417. That charge doesn't carry any fine or prison incarceration. The penalty for that is the loss of that vehicle to the government. You understand that?
Yes, sir.
And you understand the penalty in count 2 as well?
Yes, sir.
All right. Now, have you discussed the charges in each of these counts, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise in trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No, sir.
Now, at the top of page 3, there are about 2.5 lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 2 and count 4. State will dismiss remaining counts. State and defense jointly recommend 3 years mandatory incarceration. Defendant agrees to the forfeiture outlined in count 4. Is that your understanding of the agreement?
Yes, sir.
Now, under the law, Mr. West, the matter of sentence is up to the judge, not to the parties, so even though there's a recommendation you should receive the minimum mandatory sentence, that is not binding on the court. If you plead guilty, the court could decide that you should receive a sentence of more than that, up to 11 years. Also that there could be a fine. There is a mandatory fine. It might be waived, but the court could also impose fine of up to $20,000. You understand that?
Yes, sir.
All right. Now, you have certain constitutional rights. Well, before we go there, do you hold any license or certification from any state governmental agency that regulates or oversees any profession?
No, sir.
Like a nurse.
Oh, yeah, no, sir.
Okay. Now, you do have certain constitutional rights, you must understand, before I can accept a plea. First of all, you have the right to counsel, and Ms. Witt was appointed to represent you. That appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you would like her to provide. So if you decide you don't want to enter a plea of guilty to these charges, she'll continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence is presented, the judge instructs them on the law. That jury then decides by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt by proof beyond a reasonable doubt. And again, unanimous means all 12 would have to agree. Do you understand that?
Yes, sir.
Now, you have, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means you give up the right to have a jury trial, in which case you could have what's called a court or bench trial. And that means that instead of a jury, the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the constitutional laws of the state, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney, which means that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order called a subpoena, and that would force those people to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a presumption of innocence, which means you cannot be forced to testify in this. The presumption of innocence means that you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof is on you to try to prove you're not guilty simply because you've been charged. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right. Now, originally you entered a plea of not guilty to the charge. Actually, all 4 charges. And the not guilty plea denies the allegation in the indictment, denies you committed any crime, and it exercised or invokes all the rights I've just described. If you change your plea from not guilty to these 2 charges, that is the opposite of a not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime, and that plea waives, gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you in open court, cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. Waives, gives up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. The plea of guilty subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Now, Mr. West, do you have any questions about the charge in count 2 or 4 or the penalties?
No.
You understand those?
Excuse me?
You understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
And again, you understand the recommendation on the sentence is binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No.
Do you understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that here today?
Yes, sir.
Well, first of all, do you have any questions?
No, I don't have no questions.
Now, do you understand?
Yeah, I understand.
Okay. Now, would you like to speak with your attorney about anything before we go any further?
No, we're good.
Have any questions about anything that we've talked about here this morning?
No, sir.
Then is it your decision to withdraw your not guilty plea to counts 2 and 4 and enter pleas of guilty pursuant to the terms of this plea agreement?
Yes, sir.
Can you do that voluntarily?
Yes, sir.
All right. Then as to count 2, that alleges that on or about December 2, 2025 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds 50 times the bulk amount but is less than 100 times the bulk amount, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another in violation of Section 2925.03A2 of the Ohio Revised Code, charge of aggravated trafficking of methamphetamine, a first-degree felony, carrying a mandatory prison term of at least 3 years, up to 11 as a minimum set by the judge, with the possibility of being extended under the terms that I explained earlier by up to 1/2 by the Department of Rehabilitation and Corrections, a fine of $20,000, a mandatory fine of $10,000. How do you plead?
Guilty.
As to count 4, that alleges that on or about December 2, 2025 in Highland County, Ohio, you had in your possession known the 2018 Chevrolet Silverado with the VIN number listed here in the indictment, transported methamphetamine in the truck, and the property is subject to forfeiture due to its instrumentality in the commission or facilitation of the offense, as defined in ORC 2941.1417, which would result in the loss of that to the government. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court finds that on this day in open court, the defendant was endowed with all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. Defendants found guilty of counts 2 and 4 as charged. Counts 1 and 3 are dismissed. All right. Now, there's no pre-sentence report requested or required. And given the fact this is a mandatory sentence and there's a stipulation as to the sentence that should be imposed, although not binding on the court, the court will go ahead and proceed with sentencing forthwith. Mr. King, anything on behalf of the state?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation. The forfeiture in this case is a vehicle that would be forfeited to the Greenfield Police Department, and I would just ask that the clerk be ordered to issue a title for that vehicle to the Village of Greenfield. That's all. Thank you.
Swit?
Yes, Your Honor. We also ask the court to follow the joint recommendation. In meeting with Alan since his preliminary hearing, he's been very accountable for his actions and ready to accept his consequences. So I think that he's looking forward to hopefully putting this behind him and finally changing his life for the better once he's released. So we just ask for you to follow the joint recommendation and also waive any fines or suspend fines.
Mr. West? Anything you'd like to say?
No, sir.
Go ahead, stand.
No, sir.
All right. Then it's the order of the court that you be and are hereby sentenced to a mandatory minimum term of 3 years in the Department of Rehabilitation and Corrections. Now, that is a mandatory minimum. However, under the Reagan-Tokes law, the Department of Rehabilitation and Corrections could extend that if they choose. The presumptive release date will be the 3 years, and it appears you were arrested on the 19th of February and released on the 27th. Is that correct?
Yes, sir.
All right, so that would be 8 days credit. And then you'll get credit from today until you're delivered to the institution. Once you serve the 3 years minus that credit, then there's a presumption you'll be released, but that could be overcome if the department, through an administrative process and hearing, makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society, any restrictive housing you may have been under while incarcerated, and what your security classification was during incarceration. And if those findings overcome the presumption, then the department has the right to extend your incarceration by an additional period at their discretion, and they can do that on more than one occasion. However, the maximum that could be extended would be half of 3 years, or 1.5 years, so that would make the maximum possible sentence 4.5 years. Now, has there been any change in your financial circumstances since you were charged and witness appointed representation?
No, I was just been released for like the last week, and then I get my job back when I get out. But as of now,
All right. Well, the court will find then that you're not able to pay the mandatory fine. It's unlikely you'll be able to do so in the near future, and I'll waive it. Now, once you complete the sentence, Mr. West, of incarceration, the mandatory minimum, and if there should be any extension by DRC, it is mandatory that you be supervised by the adult parole authority under post-release control for a minimum of 2 years, up to a maximum of 5 years at their discretion. You'll be supervised on the terms they set by a parole officer. If they determine during that period that you have failed to comply, then they can return you to prison as a sanction to make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. However, if your violation, or if you are convicted of a new felony while on post-release control, in this case, then, and sentenced to a prison term, the judge in that case then could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. It's also ordered then that the 2018 Silverado listed in count 4 of the indictment be forfeited to the Greenfield Police Department, and the clerk reports is ordered to issue a title to accomplish that. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded to custody, Mr. West.
Can I approach, Your Honor?
You may.
You can take this.
All right, this is case number 25-CR168, State of Ohio versus Megan Renee Penwell. And are you Megan Renee Penwell appearing there on the screen marked Megan Penwell?
Yes.
All right. Ms. Penwell has been indicted on aggravated trafficking and aggravated possession of methamphetamine charges, third-degree felonies. The matter was set for a plea hearing this morning. Her attorney is Jacob Wagner. The state, he's appearing from his office, and the state is represented by prosecuting attorney Collins, appearing from her office. This hearing is being conducted by Zoom. Mr. Wagner, are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir.
And is that all right with you, Ms. Penwell?
Yes, sir.
All right. Since you're not seated in the court next to your attorney, if at any time during this hearing you need to speak with him or ask him a question, you let me know, and I will put you into a breakout room where no one else will be able to see you or hear you, and your conversation then can be confidential. Okay?
Yes, sir.
All right. So, Ms. Penwell, I have a plea of guilty form here that is 3 pages. I'm going to hold up page 1 to the camera, has your name and case number, and then indicates you're pleading guilty to count 1. You recognize that form, Ms. Penwell?
Yes, sir.
All right. On page 3, there's a sentence that says, I enter this plea voluntarily, and immediately below that appears to be signature Megan P. with a slash. And is that your signature?
Yes, sir.
And when did you sign this agreement, Ms. Penwell?
It's been a couple weeks, Your Honor.
Okay. And where did you sign it? When you were at the treatment facility, or?
Yes.
All right. Now, had you spoken with Mr. Wagner before you signed this agreement?
Yes, sir.
Did he explain everything to you?
Yes, sir.
And you read it over before you signed it?
Yes, sir.
And you understood that it's agreement to plead guilty, which means there's not going to be a trial. The next step in your case would be a sentencing.
Yes.
And you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
Since it's been a couple of weeks that's passed since you signed it, have you had any change of mind, or is it still what you want to do?
It's still what I want to do.
And you're doing this voluntarily?
Yes, sir.
All right, so the agreement says you're pleading guilty to the first count of aggravated trafficking of methamphetamine under Section 2925.03A2 of the Ohio Life Code, a third-degree felony. Further states you understand that the penalty for that could be between 9 and 36 months of incarceration. There could be a fine of up to $10,000. There's a mandatory fine of $5,000. Prison is not mandated for this offense, although it is presumed to be the appropriate sentence, but it's not required. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
Just this one.
Okay, well, this is pre-trial supervision, but other than this case, no other supervision. All right. Under the law, Ms. Manuel, if you should be sentenced to prison for this offense, upon completion of that term, the law provides that the adult parole authority has the right, if they want to exercise it, it's optional, to put you under post-release control supervision for an additional period of up to 2 years. You'd be supervised, if they did that, by a parole officer on the terms they set, and if during that period of supervision they determined that you had failed to comply, then they could return you to prison as a sanction, make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever the prison term was for all violations. However, if you commit a new felony while on post-release control and receive a prison term, then the judge in that case could also sentence you for committing that offense while on post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes, sir.
Now, as I said, there's a presumption that prison should be imposed for this offense, but it's not required. So the court does have the authority to put you under community control or probation for a period of up to 5 years on the term set by the court. And if during that, and you'd be supervised then by the probation department under those terms. If during that period of time they felt that you were not compliant, they would file a written notice of that with the court and give you a copy. There would be a hearing at which you would be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to a period of between 9 and 36 months and fine you $10,000. And if that occurred while you were on or if you committed a new offense while in community control and received a prison term for that, that would also could be required to be served consecutively in the sentence in this case. Do you understand that?
Yes, sir.
All right, now, the charge in count 1 alleges on or about November 9, 2025 in Highland County, Ohio. Let's see. We have a superseding indictment in this, don't we?
Yes, sir.
Well, I see she was served on February the 20th. Did we arraign her on this? Because I don't even have the superseding indictment, and I'm having trouble finding it here. Let me
Your
look.
Honor, I checked, you may have indicated, I talked to her caseworker to make sure she got it. They indicated she was served. I mean, you verified that.
Well, my question, though, is whether she'd ever been arraigned on it.
Not with me present, sir.
All right. Well, number one, I need to find the superseding indictment, right? All right, there it is. All right. All right, so Mr. Wagner, since this is technically, she's not been served with the indictment, arraigned on the indictment, do you waive the arraignment and free to go forward here with this plea form, with this plea
Yes, sir.
on the superseding indictment that was filed on February the 3rd?
Yes, sir. We waive any reading of that, Your Honor, any procedural defects as well.
All right. And Ms. Penwell, you received your superseding indictment, it looks like maybe on the 20th of
Yes,
February? Okay. So you're aware that the indictment was changed to add some language in the first count?
Yes.
Okay. All right. You're okay with going forward then?
Yes, sir.
All right. So the superseding indictment, count 1, reads, and then filed on February the 3rd, 2026, that on or about November 9, 2025 in Highland County, Ohio, that Bryce Isaac Penwell and you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, when the said Bryce Isaac Penwell and you knew or had reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another in violation of Section 2925.03A2 of the Ohio Revised Code. And so that's the charge of aggravated trafficking with the penalties I described earlier. Now, Ms. Penwell, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
And have you discussed the charge in the case, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Now, on page 2, there are about 2.5 lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss count 2. State defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully in prosecution of co-defendant. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that as to what the sentence should be, that is not binding on the court. The court could determine after all the information presented that that's not the appropriate sentence and could impose that sentence of incarceration and a fine. Do you understand that?
Yes, sir.
I just happened to notice that Mr. Penwell was on the screen. Who's his attorney? He's not on the docket.
He's already entered a plea, Judge. I'm not sure why he was on there.
Oh, okay. I wondered. All right. Yeah. All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, you have certain constitutional rights, you must understand, before you can accept a plea, before I can accept a plea. First of all, you have a right to have counsel, and I appointed Mr. Wagner to represent you. His appointment was not simply to work the case out, but to provide any defense that may be available to you under the law that you'd like him to provide. So if you decide you don't want to do this, if you want to defend against the charge, he'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
All right, now, under the Constitution, you have a right to have a jury trial in this manner in which 12 people would be selected from a group of people that live in Highland County that are summoned for a jury duty in your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law. Then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, in which case there would be a court or bench trial, meaning the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the right to confront the witnesses against you in open court, cross-examine them through your attorney. That means that the witnesses against you have to come into court and testify in public in front of you and your attorney and anyone else is observing. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses that are not certain to come in voluntarily, at your request, the court will issue a court order, subpoena, that forces them to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. You understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. So the burden of proof isn't on you to try to prove that you're not guilty of this charge simply because you've been accused. The burden of proof is instead upon the state, and they must prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, and that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of the charge. You have a privilege against self-incrimination. And what that means is that you're not required to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right. Now, originally you entered a plea of not guilty to the charges in this case. That denied the allegations in the indictment, denied you committed any crime, and it exercised and revoked all the rights I just described. If you change your plea from not guilty to guilty today, that's the opposite of not guilty plea. That's to count 1. And that plea would waive or give up all the rights I've described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would also waive or give up your presumption of innocence, because if you plead guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge of count 1 or the possible penalty?
No, sir.
You understand it?
Yes.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You understand that the recommendation on sentencing is not binding on the judge?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Now, is there anything you need to speak with your attorney about before we go any further? If you do, I can put him into a breakout room with you and just be the two of you on the screen.
I don't believe so. No.
All right. Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the agreement we've just gone over?
Yes, sir.
All right. Then with regard to count 1 of the indictment that alleges that on or about November 9, 2025 in Highland County, Ohio, that Bryce Isaac Penwell and you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, and distribute methamphetamine, amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of section 2925.03A2 of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months and a fine of up to $10,000. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted, order filed, defendants found guilty of count 1 as charged, count 2 is dismissed. Court refers the matter for a pre-sentence report to the probation department. Sentencing will be set for April 16th at 1 o'clock. All right. Is there anything further from counsel?
No, sir.
All right. Probation will be reaching out to you to conduct your interview, Ms. Penwell, so we'll make sure you talk with them. All right. Thank you.
Okay.
All right. This is case number 25-0175. State of Ohio versus Tad Ryan Mills, actually. And are you Tad Mills appearing there on the screen, Mark Tad Mills?
I am, sir.
All right. And this is a pretrial being conducted by Zoom. Mr. Mills is appearing from on screen. His attorney is Dennis Kirk, appearing from his office. And the state's represented by Prosecuting Attorney Collins, appearing from her office. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. And this is a first pretrial, final pretrial set for the 15th of April, and jury trial May 14th. All right. And I see that there was a motion for intervention in lieu of conviction. Did you receive, was a discovery request here, Mr. Kirk, because I don't see it in the file?
I believe so. I believe I've received discovery.
Oh, here it is. Yeah, here it is. It's underneath something else. I got it. All right. And the state agreement, okay, yeah, the stipulated questions are attached. All right. And I have these stipulated questions on the issue of whether or not you could be considered for intervention in lieu of conviction, Mr. Mills. And is that your signature on this document?
Yes, sir.
All right. And everything on this is correct?
Yes,
To
sir.
the best of your knowledge? All right. All right. The court then will order that you be referred to the probation department to be considered for intervention and undergo an evaluation. Are you currently in treatment?
Yes, sir. I'm at the Phoenix Center.
All right. Well, you'll need to, they'll talk with you about it. You'll need to sign an authorization to release information to probation so that they can provide that to the court, because what's being suggested here is that if you plead guilty, instead of being found guilty, you'd have the opportunity to complete treatment, and if it was successful, have the charge dismissed. But in order to do that, you have to be in a certified program, and Phoenix qualifies, but we have to have that documentation. So you'll need to make sure you cooperate with them on that. So we will set this for a hearing on the evaluation on April 30th at 1 o'clock. So you'll need to contact probation to get that scheduled.
Yes, sir.
So do that right after you get off the hearing here. All right. Anything further from counsel?
No, Your Honor.
All right. Your other hearings will be vacated, or at least the next pretrial, until we consider. Actually, I think the trial was set the 29th, wasn't it? So we'll vacate both of those. Actually, trial set for May 14th. Final pretrial on the 15th is vacated. You won't have to be here for that one. Your hearing will be on the 30th of April. For right now, the trial date will remain on. Okay, thank you. Six, State of Ohio versus Christopher Van Allen. And are you Christopher Van Allen appearing there from the probation department, I should say?
Yes, Your Honor.
All right. This is a Zoom pre-trial. Mr. Van Allen is appearing from the probation department, as indicated. His attorney is Dennis Kirk, appearing from his office. Appearing on behalf of the state's prosecutor Collins. Defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. I see that a bill of particulars and discovery was provided. This is a first pretrial, the final pretrial set for the 15th of April, and trial date set on May 11. I do have a motion for intervention in lieu of conviction, and I see there are some stipulated questions that were signed, and I'm going to hold up page 2 of this document. Mr. Van Allen appeared to have your signature dated yesterday next to your attorney. Is that your signature there?
Yes, sir, it is.
All right. And all the information on here is correct?
It is, sir.
All right. And are you in a treatment program at the moment?
No, I'm not.
All right. All right. The court then will order that the case be referred to probation department for a pre-hearing report and an evaluation. And you'll need to, in order to be allowed to be in this program, there has to be an assessment that you have a substance use disorder issue and or mental health that contributed to the events in this case and qualifies you for this, and that requires you to be in a treatment program. So you'll need to speak with Officer Benson on your way out to schedule that. We will set the hearing on this matter for April the 30th at 1 o'clock.
Okay.
So you won't have to appear at your next pretrial.
Okay.
All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you.
Thank you, sir.
That's everybody, right?
Yes, sir.
All right, are you James Sean Padgett Jr. appearing there from the jail?
Yes, sir.
Okay, this is case number 25 CR 155. State of Ohio versus James Sean Padgett Jr. This is a pretrial. Mr. Padgett is appearing from the Justice Center by Zoom. His attorney is Jacob Wagner, appearing from his office. Mr. King is appearing on behalf of the state from prosecutor's office. The defendant is charged with failure to comply with the order signal of a police officer, a third-degree felony, and tampering with evidence. The matter is set for trial on April the 20th, and this is the first pretrial. Now, Mr. Padgett, or Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are. Respectfully, Your Honor, may I address the court?
Yes.
And maybe I have it wrong, but I had make sure the court has two cases on this, Your Honor. It's 25 CR 155 and 26 CR 119 or 19.
Yes, sir. Yep. Thank you very much. Yeah.
Yes, sir.
The additional case is 26 CR 19. State of Ohio versus James Sean Padgett Jr. Yes, and that in that case he's charged with prohibitions concerning companion animals, a fifth-degree felony, and the trial date on that is set for April 15th. All right. Now, Mr. Padgett, are you okay with conducting this hearing by Zoom rather than in-person appearance in the courtroom?
Yes, sir.
All right. Since you're not seated next to your attorney in the courtroom, if at any time you need to talk to him or ask him a question, you just tell me. I can put you and him in what's called a breakout room. It'll be just the two of you on the screen. None of the rest of us will be able to see you or hear you, and the deputy will step out of the room while you're talking with your attorney privately. Okay? All right. So I've been provided plea agreements in each of these two cases. So I'm going to address the 25 CR 155 case first. In that one, Mr. Padgett, it indicates you're going to plead guilty to failure to comply with the order signal of a police officer. I'm going to hold the first page of that up to the camera and ask if you recognize that agreement. On page 3, there's a sentence that reads, "I enter this plea voluntarily." And then right below that, there appears to be a signature, James Padgett. I'll hold that up to the camera and ask if that is your signature. All right. In case number 26 CR 109, we also have a plea of guilty form. It says you're going to plead guilty to the charge of prohibiting prohibitions concerning companion animals under 959.131 and 99 of the revised code, fifth-degree felony. I'll hold that up and ask you if you recognize that agreement. And on page 3, the same sentence, I enter this plea voluntarily. And below that, there appears to be a signature of James Padgett next to an X on a line. And is that your signature?
Yes, sir.
When did you sign these agreements, Mr. Padgett? And when you signed them, did you understand that they were agreements to plead guilty, meaning there won't be a trial, and the next step in your case would be a sentencing?
Yes.
And before you signed it, did your attorney go over it with you and explain everything to you?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before making the decision? You feel you've been rushed or pressured in any way?
Yes, sir.
And you're entering into these agreements voluntarily?
Yes, sir.
All right, so in each agreement it says you're going to plead guilty to count 1. In 25 CR 155, that's failure to comply with the order signal of a police officer under section 2921.331B of the Ohio Revised Code, a third-degree felony. And states you understand that the sentence for that could be between 12 and 60 months and a fine of $10,000. There is a requirement that there will be a license suspension of 3 years to life. And if prison terms imposed in any other felony case to prison, then that could be would be served consecutively. You understand that? All right. Now on the 26 CR 19 case, it indicates that you are going to plead guilty to the prohibitions concerning companion animals, a 5th-degree felony, and that you understand the term of that could be 6 to 12 months and a fine of $2,500. You understand that? All right? Counsel, I have a question to ask if either of you have discussed this. Mr. Paget does not have a prior felony of violence, but the F3 and 155 is. And in the other cases, a 5th-degree felony, it's not an offense of violence, I don't believe. I know that the failure to comply says you have to have a sentence has to be served consecutively. But I believe that the 26 CR 19 case is a TCAP case.
I thought that at first also, Your Honor, but I believe that I thought that would be overridden by the failure to comply charge, which requires a mandatory sentence on another charge.
Yeah, see, wouldn't the the quandary I'm thinking is this consecutive sentence would, in the failure to comply statute, would be based on a sentence of incarceration. I'm trying to find the TCAP language. You know, I'm going to have to step off the bench here and go see if I can find that, so put us on the break. All right, I found it. I had it here behind me. It has to be an offense of violence, sex offense, or trafficking offense, or other mandatory term. Offender has a prior conviction for a sex offense or a felony offense of violence. The sentence is be considered currently to a prison-eligible felony offense. Or
Your Honor,
Your Honor, may I
Yes, go
bring
ahead.
something up? I was just looking at this defendant's criminal history. Yeah, he does have a misdemeanor sex offense conviction in 2014.
Yes, I was just looking at that. So I do believe that does make it the TCAP, takes it out of TCAP. Yeah. All right, so based on that, gentlemen, it does appear then that both sentences would be prison time if he goes ahead and goes forward. Mr. Wagner, you have anything you want to bring up?
I gotta say, Mr. King and I had that same discussion when going through the forms, Your Honor.
Okay.
I kind of agree with his original statement, sir.
Yep. All right. All right. So, Mr. Paget, are you facing any felony charges in any other cases in this state? All right. And if you would try to keep your voice up because your microphone's further away. I'm hearing you, but I'm concerned we're not getting your voice on the recording. Are you currently on probation, community control, parole, or post-release control for a felony? All right. Now, under the law, if you are convicted of these offenses with regard to the failure to comply with the order signal of a police officer charge, upon completion of any sentence that would be imposed, it is mandatory that you be put under post-release control supervision by the Adult Parole Authority for at least 1 year, up to a maximum of 3 years at their discretion. With regard to the 19 case, it's optional for up to 2 years. But for the failure to comply, it's mandatory. So you will be supervised under the term set by the Adult Parole Authority by a parole officer, and if they determine that you have failed to comply with those conditions, they can return you to prison to make you serve an additional sanction time of up to 9 months for a single violation, but there's a maximum of or cap of half of whatever the prison term was for all violations. But if you are convicted of a new felony committed while under post-release control supervision and are sentenced to prison, then in that case, the judge in that case could also sentence you to serve the period of 1 year or whatever time was remaining on the period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that? Again, you're going to have to speak up.
Yes, sir.
Okay, thank you. Better. Much better. All right. Now, neither of these cases are mandatory prison sentences, the court is permitted by law to sentence somebody convicted of these offenses to a term of community control or probation of up to 5 years, where you would be supervised by a probation officer in the term set by the court. If during that period of time the probation department felt that you were not complying, they would file a written allegation of that with the court, give you a copy. There would be a hearing in which you would be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time your community control could be revoked. You could be sentenced to a term of 12 to 60 months in the 25 CR 155 case, 6 to 12 months in the 26 CR 19 case to be served consecutively. So that would mean a total potential of 12 to 72 months, plus fines totaling $12,500. And if you were convicted of a new felony committed while on community control and received a sentence in that case, that sentence and the sentence in these cases will be served consecutively to one another. Do you understand that?
Yes, sir.
All right. Now, in case number 25 CR 155, the charge is that on or about July 15, 2025 in Highland County, Ohio, you did operate a motor vehicle as defined in section 4501.01 of the revised code, so as willfully to elude or flee a police officer after receiving a visible or audible sign from a police officer, to bring the person's motor vehicle to a stop, and the operation of the motor vehicle causes a substantial risk of serious physical harm to persons or property in violation of section 2921.331B of the Ohio Revised Code. So that's the charge of failure to comply the third-degree felony with the penalties I've explained earlier. In regards to case number 26 CR 19, charges that on or about February 7, 2026, continuing through February 8, 2026 in Highland County, Ohio, that you and a Haley Marie Kelly did knowingly cause serious physical harm as defined in ORC Section 959.131A12 to companion animals defined in ORC 959.131A1 in violation of 959.131C of the Ohio Revised Code, which is a fifth-degree felony, carries possible prison term of 6 to 12 months, a fine of $2,500. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how you allege that you did it?
Yes, sir.
And if you discuss the charges in each case, the evidence that pertains to those, the possible legal issues may exist in each case, possible defenses you could try to raise at trial in each case, and the possible outcomes of each case with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you in any way to make you plead guilty here today?
Yes, sir.
Now, on page 2 of each agreement, there's some language that I believe is identical, and so I'll read it into the record from 26 CR 19. I'm sorry, 25 CR 155. It reads that the defendant shall enter a plea of guilty to count 1. The state will dismiss count 2. State defense jointly recommend 18 months of incarceration to be served consecutively to the sentence in case number 26 CR 19. State will not oppose judicial release to substance abuse treatment after 6 months of incarceration. Then the 26 CR 19 case, defendant will enter a plea of guilty to the indictment. State defense jointly recommend 9 months of incarceration to be served consecutively to the sentence in case number 25 CR 155. State will not oppose judicial release to substance abuse treatment after 6 months of incarceration. Defendant agrees to cooperate fully in prosecution. Co-defendant, defendant agrees to pay restitution to Highland County Humane Society, amount of $142.22, joint and several with co-defendant Haley Marie Kelly. So they weren't quite the same. There was some differences. Now, are each of those the agreement that you've entered into with the state through your attorney?
Yes, sir.
And has anyone promised you anything other than that to get you to plead guilty?
Yes, sir.
Now, under the law, the matter of sentence is up to the judge. So even though there's an agreement that you plead guilty, all right, and you're going to get a certain sentence, whether you get that sentence or not is up to the court. So if you plead guilty, the court is not required to follow the recommendation. I could instead sentence you to the maximum of 60 months in the 25 CR 155 case, 12 months in the 19 case, consecutive. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
What was it?
Do you hold any kind of a license or certification from an agency of state government that regulates any kind of a profession?
No.
Okay. All right. Now, you have certain constitutional rights you must understand before I can accept a guilty plea. First, you have a right to have counsel in this matter. And I did appoint Mr. Wagner in each case to represent you, since you didn't have the money to hire your own attorney. Now, his appointment wasn't to work the case out, but rather to provide whatever defense may be available to you under the law. So if you decide that you do not want to do this, the case will go ahead and proceed. Mr. Wagner will continue to represent you and defend you, including going to trial in either or both cases if that's what you want. You understand that?
Yes, sir.
All right. Now, in each of these cases, you have a right to have a jury trial, Mr. Paget, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 people are selected, the evidence is presented. The judge then instructs the jury on the law. And then that jury would decide in each case by unanimous verdict, because there would be 12 jurors in each case. So the verdict in each case would have to be unanimous, meaning all 12 would have to agree. You understand that?
Sure.
All right. Now, in each case, you have If you decided you didn't want to have a jury trial, but you didn't want to go to plead guilty, you could waive in writing your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one that would hear the evidence, apply the law, decide whether or not the state proves your guilt. Do you understand that? Now, in each of these cases, you have the right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you and your attorney and anyone else is present in each case. Once the prosecutor was done asking the witnesses questions, then your attorney could ask questions of those witnesses, and that's called cross-examination. And the purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution and laws of the state, you have right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses in either case that you're not certain would come in or are able to come in voluntarily, at your request, the court would issue a court order called a subpoena, and that would force those witnesses to come into court to testify in each case that you requested, whether they wanted to be here or not, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that? Do you understand that?
Yes, sir.
Okay, thank you. Now, under the law and the Constitution of this state and the country, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in either case at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify in either or both cases, the jury in that case would be instructed that they cannot consider it for any purpose. And in fact, no one's allowed to even comment about it. There is one exception that the court would instruct the jury if you decided not to testify in either or both cases, that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense in that particular charge. So what that means is that the burden isn't on you to try to prove you're not guilty in either case simply because you were indicted and accused. In fact, under the law, you don't have to present any evidence at all in your own behalf. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense in that case by proof beyond a reasonable doubt. And that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally entered a plea of not guilty in these two cases. Plea of not guilty denied the allegations in each case, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty today, that is a complete opposite of the not guilty plea. The guilty plea, if that's what your plea is on these cases, admits the allegation in each count of the case in which you're pleading guilty, count one in each case, admits that there's crime as alleged and that you committed the crime alleged. And that plea gives up all the rights that I've described for you today except your right to have an attorney. You always have a right to have an attorney no matter what you're pleading. But with that exception, your plea of guilty, wage gives up your right to a jury or court trial. Wage gives up your right to confront witnesses against you and to cross-examine them through your attorney. Wage gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Wage gives up your privilege against self-incrimination because if you plead guilty in these two cases, then that plea is what's used to find you guilty. It also waives your right to require the state to prove your guilt in either case because if you plead guilty, then the state's not required to prove you're guilty because that's what's used to find you guilty. Now, a plea of guilty will subject you to being sentenced immediately by the court, and it also waives gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other limited circumstances you can file an appeal, that would have to be filed within 30 days if your sentencing entry being filed. Do you understand that?
Yes, sir.
All right. And you are a U.S. citizen, Mr. Padgett?
Yes, sir.
All right. Now, do you have any questions about the charges or the possible sentences? You understand that?
Yes.
You have any questions about the plea agreement?
No, sir.
You understand that the matter of sentences, again, is up to the judge, not to the parties, and I don't have to follow the recommendation in the plea agreement.
Yes, sir.
Okay. I didn't explain that, but it also applies that if I follow, whether I follow the recommendation or not, if you file for judicial release, again, the no opposition by the state is not binding on the court. The court will make the decision based on the information at that time. You understand that? You have any questions about the constitutional rights I've explained?
No, sir.
You understand them?
Yes.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea of guilty in these two cases today?
Yes, sir.
Okay. You understand?
Yes.
Okay. Now, is there anything you'd like to speak to Mr. Wagner about before we go any further?
No, sir.
You have any questions about anything that I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to count one in each case pursuant to the terms of the plea agreement we've gone over in each case?
Yes, sir.
All right. Then as to the charge in case number 25 CR 155, count 1, that alleges that on or about July 15, 2025 in Highland County, Ohio, you did operate a motor vehicle as defined in section 4501.01 of the revised code so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle causes substantial risk of serious physical harm to persons or property in violation of section 2921.331B, the charge of failure to comply with third-degree felony with the penalties that I have previously described. How do you plead? With regard to the charge in count 1, single count of the 26 CR 19, that reads that on or about February 7, 2026, continuing through February 8, 2026 in Highland County, Ohio, that you and Haley Marie Kelly did knowingly cause serious physical harm as defined in ORC section 959.131A12 to a companion animal as defined in ORC section 959.131A1 in violation of section 959.131 of the Ohio Revised Code, a fifth-degree felony, carrying a possible term of incarceration of 6 to 12 months, a fine of $2,500. How do you plead?
Yes, sir.
All right, thank you. The court finds that on this day in open court, the defendant was advised of all his constitutional rights in each case and knowingly, intelligently, and voluntarily waived those rights. He has knowingly and voluntarily entered a plea of guilty to count 1 in 25 CR 155 and is found guilty of that, and pleas accepted and order filed. Count 2 is dismissed, and he is found guilty as charged in single count in 26 CR 19. All right. Now, given the nature of the charge in 25 CR 155 and the agreement of the parties as to what the sentence should be, the court is going to go ahead and proceed with sentence forthwith. So, Mr. King, anything you'd like to say?
Only one to take the plea agreement, sure.
All right, Mr. Wagner?
I'd ask the court to go along with the plea agreement. I met with my client a couple times. I think just looking at the docket, you can see how quick he handled this case. I think from bond review on March 5th to today, he's got this case resolved in less than 2 weeks, Your Honor. Very nice client to deal with, straightforward, honest. At least to me, I'm not saying his conduct was honest. I'm saying he was honest and forthright with me. I would ask the court to go along with the plea agreement, Your Honor.
Mr. Padgett, is there anything that you would like to say? So it looks like you're arrested on February 26th, is that correct?
Yeah, I was in Greene County from the 12th to the 26th.
Why were you there?
Probation violation, when they dropped my probation.
When were you released? So you were serving some time for them up there, and then you got released to us?
Yeah.
And when was it you were released to the Highland County?
At least like the 22nd over there in Green County.
22nd. All right. Okay. All right. With regard to case number 25 CR 155, it's the order of the court that you be sentenced to a term of 24 months of incarceration. And with regards to case number 26 CR 12, it's ordered that you be sentenced to a term of 9 months incarceration. Those sentences will be ordered to be served concurrently with each other. According to the arrest information I have, appears you have from February 22nd till today would be 24 days. And so the court is going to, will give you credit for those 24 days. Now, in the event that you are required to serve the full sentence, Mr. Padgett, in these cases, upon completion of that sentence, the Adult Parole Authority in case number 25 CR 155 will place you under post-release control supervision for at least a period of 1 year, and it could be up to 3 years at their discretion. With regard to 26 CR 19, it would be optional up to 2 years, but we know it's going to be required in the other case for at least 1 year and up to 3. Now, if you violate any of the conditions that they place while you're being supervised, they have the right to return you to prison as a sanction to serve an additional period up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if your violation is a new felony and you're sentenced to a term of imprisonment in that case, then that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on the period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. It's also ordered that you pay the court costs, which judges granting execution order. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your sentence, not while you're in prison, but once you're out, you could be permitted to do community service in this county. You'll be given credit for each hour you worked and an hourly rate set by the court. Each hour you worked would reduce your judgment by that amount until paid in full. It's also ordered in case number 26 CR 19 that you pay restitution to the Highland County Humane Society in the amount of $142.22, joint and several with your co-defendant. That's to be paid through the Highland County Victim Witness Escrow account, and you'll pay any service fees connected with that. All right, is there anything further from counsel?
Yes, Your Honor, I've got several things. First, I just wanted to clarify the sentences. Are these concurrent or consecutive?
Concurrent.
You said concurrent.
I did say concurrent.
Okay. The other question I had is 24 days jail time credit. Which case does that go to first?
It'll go to the first one indicted, I guess, so that would be the 25 CR 155 case.
Okay. And then last, the driver's license suspension.
Oh, thank you. Forgot that. Yeah, in case number 25 CR 155, it's mandatory your license be suspended for at least 3 years, so that's the order of the court to be 3 year suspension beginning today. Once you're released, if you can show proof of insurance and you have otherwise you're able to drive, not have any other suspensions, then the court would grant limited driving privileges for that purpose. Anything else?
That's all, Your Honor. Thank you.
All right.
No, sir.
All right, thank you. You're remanded back to custody. This is case number 25 CR 166, State of Ohio versus Kimberly Rose Hickok. This is a hearing being conducted by Zoom. Ms. Hickok's appearing from the jail. Her attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Defendant is charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. This is a final pretrial and trial set for April 6th. I do see a proposed plea of guilty. Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir.
You all right with that, Ms. Hickok?
Yes, sir.
All right, so if at any time during this hearing you would like to speak with your attorney about anything, then let me know. I'll put the two of you into a breakout room, and he'll be able to talk with you. No one else will be able to see you or hear you, and the deputy will step out of the room while you're doing that, okay? You understand?
Yes, sir.
All right. Now, I have a plea of guilty form that says you're going to plead guilty in this case. I'm going to hold it up to the camera on page 1. Has the name and the case number and plea of guilty form. Do you recognize that document?
Yes, sir.
Page 3, there's a sentence that reads, "Enter this plea voluntarily." And immediately below that, there is a signature line. It looks like Kimberly Hickok. I'll hold that up to the camera, and is that your signature?
Yes, sir.
When did you sign this agreement?
This morning.
When you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And before you signed it, did you go over with your attorney and have him answer any questions that you had?
Yes.
Do you feel that you were pressured or rushed in any way into doing this?
No, sir.
And you're going forward with this plea of guilty today voluntarily?
Yes.
All right. Now, the agreement states that you understand that the potential sentence for this offense is 6 to 12 months of incarceration, a fine of $2,500. And you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you should be sentenced to prison for this offense, upon completion of that prison term, the law provides that the adult parole authority has the option, if they want to exercise it, to put you under post-release control supervision for up to 2 years. You'd be supervised by a parole officer on the terms they set. If during that period of time they found that you had failed to comply, then as a sanction they could return you to prison to make you serve an additional period of up to 9 months for, in this case, half of the prison term as a cap for all violations. So that could be a maximum of 6 months if the sentence was 12 months, or half of whatever the sentence was. But if you're convicted of a new felony and sentenced to prison while under post-release control, then the judge in the case in which you were convicted could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that post-release control, whichever is greater. If that occurs, it has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, I'm not required to sentence you to prison for this offense. I can grant community control, which is what most people know to be probation. So instead of going to prison, you'd be put under supervision of the probation department for up to 5 years, and if during that period of time you fail to comply with the terms that were set by the court, then they could file a written allegation against you alleging that. There would be a hearing at which you would have to be entitled to have an attorney. And if the outcome of that hearing was you failed to comply, then at that time you could be sentenced to serve a period of 6 to 12 months and fined $2,500. And if you were convicted of a new felony while on community control in this case and sentenced to prison or incarceration, the sentence in each case could be ordered to be served consecutively, one after the other, in each case. Do you understand that?
Yes, sir.
All right, now the charge in this case, in this indictment reads that on or about. By the way, I'm just looking on. The indictment says count 2. that there is only one count. All right. I assume that counsel, you have no objection to the court sua sponte amending that to reflect as a single count indictment?
Correct, Your Honor. Just a mistake.
Malcolm, yes, sir.
All right, I'm making that change here. All right, so the charge in count 1 alleges that on or about May 6, 2025, in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge with the penalties I've described. Now, you understand what it is you were charged with by the state, what they said you did, when, where, and how they alleged that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the legal issues of the case, possible defense you may try to raise at trial, possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Your Honor, she has a question for you.
Okay.
Not the date on that is not correct. It's May 16th, not the 6th. I don't know if it matters, but I just wanted to. Because when I first read it, I was lost. I didn't even what the charge was.
All right. Well, anybody have any comment on that? You saying the date should be May 16 instead of May 6?
Yes, sir.
I'm looking at the indictment, and I'm going to look at
The indictment says May the 6th. I don't know anything. I don't have anything in here different.
Your Honor, if I may, the statement of the facts, the stop, I'm not sure what she's getting at. A lot of the evidence in the indictment and I up May 6th, Your Honor.
I don't have any of that, so.
Here's what I think is going on. In the brief summary of facts, it says the offense occurred on May 6th. However, further in the narrative, it said May 16th. So, I don't want to put those two dates as a typo.
I didn't get a man.
And from what I'm seeing, I think the 6th is a typo, and it occurred on the 16th.
That's what she is saying. All right.
I didn't get read it.
I think she's correct.
Okay.
And that's what the evidence receipt says as well.
All right.
Yes.
All right, so we'll amend it then to the 16th. All right.
Yes, Your Honor.
Well, thank you for pointing it out, Ms. Hickok. All right. Now, you've discussed the charge and the evidence and the legal issues and possible outcomes of trial with your attorney,
Yes, sir.
and you're satisfied with his advice and competence.
Yes, sir.
And are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to make you plead guilty?
No, Your Honor.
Now, on page 2, it states in bold and underlined, defendant will enter a plea of guilty to the indictment, state defense, joint reprimand, community control, and referral to drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not the party. So even though there is a joint agreement that you be sentenced to community control and referred to drug court, that's not binding on the court. You understand that?
Yes, Your Honor.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now you have certain rights, you must understand, before I can accept a guilty plea. First, you have a right to have counsel, and I appointed Mr. Wagner to represent you, not simply to work the case out, but to provide any defense that could be available under the law that you would like him to provide. So if you decide that you do not want to do this, that you want to defend against this charge, he'll continue to represent you and defend you, including trial, if that's what you want. Do you understand that? Now, you have a right to have a jury trial in this matter, in which 12 people be selected from a group of citizens that live in this county that are summoned for jury duty on your trial day. After 12 of those folks are selected, the evidence will be presented, and then the judge will instruct them on the law. And that jury would then decide by unanimous verdict, meaning all 12 would have to agree, whether the state proves your guilt. Now, if you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, which means to give up your right to have a jury trial, in which case you would have what's called a court or bench trial, and instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes.
Right now, under the law and the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to appear in public and testify in front of you and the jury and your attorney and anyone else is observing. Once the prosecutor has finished questioning those witnesses, your attorney then can ask questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right. Now, under the Constitution and the laws of this state, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So, that means that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Now, if you change your plea today from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. And that plea will waive and give up all the rights that I have described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive and give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and cross-examine through your attorney. Waive or give up your right to compel witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, so that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, sir.
Are you a U.S. citizen? Are you a U.S. citizen?
Yes, sir.
All right. Now, do you have any questions about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes.
You understand the plea agreement?
Yes, sir.
And you understand the recommendation of the state's not binding on the court?
Yes, sir.
You understand the plea agreement, or I'm sorry, you understand the constitutional rights I've explained?
Yes, sir.
And you understand what the guilty plea means and what the consequences of that are if you enter here today?
Yes, sir.
Now, is there anything you'd like to speak with your attorney about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here today?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge in the indictment pursuant to the terms of the plea agreement that I've gone over with you?
Yes, sir.
All right, then as to the charge, which alleges, as amended in count 1, that on or about May 16th, 2025 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying a possible prison term between 6 and 12 months, a fine of $2,500. How do you plead?
Guilty.
All right. The court finds on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the safe for load. The pleas accepted and order filed. Defendant is found guilty as charged in count 1. The matter is referred to the probation department for a pre-sentence report. The bond will be continued. Also, the case is referred to the drug court docket for defendant to consider whether she wishes to apply permission to that docket should she get committee control. All right. Anything further, counsel?
No, sir.
All right.
When did you say it's the sentencing hearing was, Your Honor?
Maybe I didn't. April 16 at 1 o'clock.
Thank you.
All right. Thank you. All right. Are you Bobby J. Nyman appearing there from the probation?
Sorry about that, Your Honor. Yes, I'm Bobby Joe Nyman.
All right. This is case number 26 CR 04, State of Ohio versus Bobby Joe Nyman. This is a pretrial being conducted by Zoom. This is a final pretrial. Trial is set for April 6th. Ms. Nyman's attorney is Danielle Witt, appearing from her office. Appearing on behalf of the state from the prosecutor's office is Assistant Prosecutor King. The defendant is charged with one count of disseminating matter of harmful to juveniles, and Mr. King was the representative of the alleged victim, notified of the time, place, and purpose of this hearing.
Yes, Your Honor, and they're viewing on YouTube.
All right. All right. So, okay. All right. I see that then I have a proposed plea of guilty form here. And so, Ms. Witt, are you and your client both in agreement this can be considered conducted by Zoom rather than in-person occurrence in the courtroom?
Yes, we are. And, Your Honor, just so you know, Ms. Nyman does have a hearing problem. So
okay. Thank you.
Not
all right. Well, Ms. Nyman, if you have any problem hearing anything I'm saying, just let me know, okay?
No problem. That's why my head's turned to the right.
Okay. All right. And you're okay then with this case being conducted by Zoom rather than appearing in the courtroom?
Yes, sir.
All right. Well, if any time during the hearing you would have something you would like to speak with your attorney about, or if you have a question you feel needs to be answered, just let me know. I'll put the two of you into a breakout room. It'll be just you and her on the screen. No one else will be able to see you, hear you, and that'll be confidential, okay?
Appreciate it. Thank you.
All right. So I have this plea agreement, Ms. Nyman. I'm going to hold up the first page that has your case number and name, and it says plea of guilty to this charge. And you recognize that document?
Yes, sir, I do.
On page 3, there's a sentence that reads, I enter this plea voluntarily, and right below that, a signature line appears to be Bobby Joe Nyman. I'll hold that up. Is that your signature?
Yes, sir.
When did you sign this document, Ms. Nyman?
Monday.
All right.
Monday.
When you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step would be a sentencing?
Yes, sir.
And before you signed it, did you talk about it with your attorney and have her answer any questions you had?
Yes, sir.
All right. And do you feel that you had enough time to fully consider the matter before you signed this agreement?
Yes, sir.
Since it's been a couple of days ago that you signed it, have you had any change of mind, or is this still what you want to do?
Still what I want to do.
All right. So the agreement says you're going to plead guilty to the charge in count 1 of disseminating matter harmful to juveniles in violation of section 2907.31A1 of the Ohio Revised Code, which is a 5th-degree felony. That carries a possible prison term of between 6 and 12 months and a fine of $2,500. And I believe in this case, is there a sex offender registration applicable for this offense? I think there is.
No, Your Honor, there's not.
It's not. Okay, it's not. Oh, that's right. We did. Yeah. Okay, you're right. It is excluded for a little surprising, but it is. All right. So those are the possible consequences. You understand that?
I do.
Now, under the law, well, let me back up. Are you facing any felony charges anywhere else?
No, sir.
Are you on community control, probation, parole, or post-release control for a felony?
No, sir.
All right. Now, under the law, if you should be sentenced to prison and convicted of this offense, after being convicted of this offense, upon release, it is possible the Adult Parole Authority would exercise the option. So would exercise the option to put you under post-release control for a period of up to 2 years. So you would be supervised under terms set by the Adult Parole Authority by a parole officer, and if they found you had failed to comply, they could return you to prison and make you serve an additional period of up to half of the prison term that was imposed for one or more violations. However, if you're convicted of a new felony and sentenced to prison, then the judge in that new felony case could also sentence you for committing that offense while on post-release control, in this case, to an additional period of 1 year, whatever time was left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
I do.
Now, the law does not require that this be a mandatory term of incarceration, so you are eligible for what's called community control or probation. And that means that instead of being sentenced to a term of incarceration, the court will put you under supervision of the probation department under terms set by the court, which could be for up to 5 years. And if during that period of time the probation department felt that you were not complying, then they would file a written notice of that with the court, give you a copy. There would be a hearing in which you'd be entitled to have an attorney. And if the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to a term of incarceration, as well as fine you 6 to 12 months and fine you $2,500. And if you were convicted of a new felony offense while on community control in this case and sentenced to prison for that offense, then those sentences could be ordered to be served consecutively to one another. Do you understand that?
I do.
All right. Now, the charge in this case alleges that on or about April 13, 2025 in this county, that you did, with knowledge of the character or content, recklessly, directly sell, deliver, furnish, disseminate, provide, exhibit, rent, or present to B, date of birth 7/5/2007, a juvenile, or a group of juveniles, a law enforcement officer posing as a juvenile, or a group of law enforcement officers posing as juveniles, any material or performance that's obscene pursuant to ORC 2907.01F of the Ohio Revised Code, in violation of Section 2907.31A1 of the Ohio Revised Code, which is the offense, as I've indicated, of disseminating matter harmful to juveniles, 5th-degree felony with the penalties I described. Now, Ms. Nyman, do you understand what it is you've been accused of having done, what the state said you did, when, where, and how they alleged you did it?
Yes, sir, I do.
Have you discussed the charge in the case, the evidence in the case, possible legal issues in the case, possible defenses you may try to raise at trial, and the outcomes of a trial with your attorney?
Yes, sir, I have. I know what I did.
And are you satisfied with her advice and competence in this matter?
Yes, sir, I am.
Are you under the influence of any types of drugs or alcohol at this time?
I smoke marijuana daily. Yes, sir, I do.
All right. Is that interfering with your ability to understand what's going on here today or to communicate accurately?
No, sir, it's not.
Has anyone threatened you to make you plead guilty here today?
No, sir.
On page 2, there were some lines that are printed in bold, and there were a couple of options, and it looks like one's been stricken through, but so it doesn't apply. So I'll read the remaining parts that are printed in bold and underlined. Defendant will enter a plea of guilty to the indictment. State defense will argue sentencing. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
So you've not been promised that if you plead guilty, you'll receive any specific sentence?
No, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
You have certain constitutional rights you must understand before I can accept a guilty plea. First, you have a right to have counsel. I appointed Ms. Witt to represent you since you didn't have the money to hire an attorney. Her appointment wasn't simply to work the case out, but to try and provide whatever defense may be available to you under the law that you would like her to provide. So if you decide that you do not want to do this, that you want to defend against the case, she'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
I do.
Right now, under the law, you have a right to have a jury trial in this matter in which 12 people would be chosen from a group of citizens that live in this county that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in writing, your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
I do.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. You understand that?
I do.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf against the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court would issue a subpoena, which is a court order, and that would force those witnesses to come to court to be able to testify if you didn't, even if they didn't want to, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
I do.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide you're not going to testify, the fact that you did not testify cannot be held against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial, you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
I do.
Now, under the Constitution, you have a privilege against you have a presumption of innocence. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been indicted and accused. In fact, under the law, you're not required to present any evidence on your own behalf at trial. You may, but you're not required. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
I do.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, and that you committed that crime. And that plea will waive or give up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives gives up your right to confront the witness against you and to cross-examine through your attorney in open court. It waives gives up your right to have a trial by jury or by court. It waives gives up your right to use the power of the court to compel or force witnesses to appear to testify for you, the same as the state. It waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you could have had up until this point in the case. Now, should I sentence you to the maximum sentence or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir, I do.
And are you a U.S. citizen?
Yes, sir, I am.
Now, do you have any questions about the charge or the possible penalties?
No, sir, I don't.
You understand?
I do.
You have any questions about the plea agreement?
No, sir.
You understand that?
I do.
You have any questions about the constitutional rights that I've explained to you?
No, sir.
You understand that?
I do.
Have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter it here today?
I do. I understand.
All right. Is there anything you'd like to speak to Ms. Wood about before we go any further?
No, sir.
Okay, you have any questions at all about anything we've discussed?
No.
Then as to the charge, which alleges that on or about April 13, 2025 in Highland County, Ohio, you did with knowledge of its character or content, recklessly, directly sell, deliver, furnish, disseminate, provide, exhibit, rent, or present to V. DOB 75-2007, a juvenile or a group of juveniles, law enforcement officer posing as a juvenile, or a group of law enforcement officers posing as juveniles in any material performance that is obscene pursuant to RC Section 2907.01F of the Ohio Revised Code in violation of Section 2907.31A1 of the Ohio Revised Code, charge of disseminating matter harmful to juveniles, a fifth-degree felony, carrying a possible term of incarceration of 6 to 12 months and a fine of $2,500. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all the constitutional rights made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Plea is accepted. Order filed. Defendant is found guilty of this offense as charged. Court will order that the matter be referred to the probation department for a pre-sentence report. Bond will be continued. Sentencing hearing will be April 30th at 1 o'clock. All right. Is there anything further from counsel?
No, Your Honor.
All right. Then you'll see the probation department before you leave to make arrangements for your pre-sentence interview.
Thank you so much.
All right. Thank you.
Thank you.